Welcome to the ANZ Business Law Series webinar. I'm Michelle Heath-Young, Associate General Counsel from the legal team at ANZ New Zealand. One of our priorities for our customers is to deliver timely expertise and insights to support your businesses to build and grow strong, sustainable businesses. In this ongoing series of webinars, our partner law firms will be covering updates on law changes impacting business. Each session will cover one or two recent law changes that business owners need to be aware of. And today, I'm delighted to be joined by Josh Williams, partner, and Megan Pearce, Senior Associate of Anderson Lloyd, one of our customers and also one of the leading law firms in New Zealand. And they support industries that make New Zealand successful. Today, we're going to focus on leading a discussion on the Privacy Act and unfair contract term changes. On your screen, you'll see some important information. And in delivering these webinars for you, we're seeking to provide information that will be helpful to you in thinking about your own business needs. It's not intended to be advice in any way, and we hope that it will trigger for you, if you have a need within your business, to go and seek that advice from your professional advisors. And as such, we don't take any liability for the information that we provide here today. And the way we will run it today is that after the first session that Megan delivers on privacy law, we'll take some questions on that, and then we'll move through to the Fair Trading Amendment Act changes with Josh. If you do have any questions relating to the first part, you can still raise them throughout, and we will moderate those questions accordingly. So what we'd like to do is simply get underway now. So I will hand over to Josh and Megan.
Thank you, Michelle. Thanks so much for the introduction, and thank you to ANZ for having us. We're delighted to be here. So kia ora everyone, welcome. I'm Josh and this is Megan, and we will be running you through the recent changes to the Fair Trading Act and some recent changes to the Privacy Act as well. And we're excited to be here, and I'll pass it over to Megan, who's going to kick it off with privacy.
Fantastic. Thank you, Josh. And to help you focus on the content today, we're going cameras off. So what I'm going to cover today is New Zealand privacy law. So here currently in New Zealand, the principal legislation which governs New Zealand privacy and data protection is the Privacy Act 2020. So this act came into force largely on 1st of December 2020 and replaced its predecessor legislation, the Privacy Act 1993. That repeal was long awaited, given the substantial development in technology over the last few years and the number of updates to international privacy laws. New Zealand was certainly awaiting reform in this space. So the new law has essentially retained the principle-based framework that the 1993 Act based upon. And it's also retained the information privacy principles. So these are essentially the governing principles that talk through how businesses and organizations should essentially collect, handle, store, use, and otherwise disclose personal information. So what is personal information? Because the Act is primarily governing and controlling personal information. So the first thing to note is that personal information is very broadly defined, and it's considered to be information about identifiable individuals. And it's best to take a conservative view when considering whether or not you're talking about personal information. There's no bright line test, and context is very important. Personal information has been found to include more obvious things such as residential address details and medical records, but also has been found to include responses to phone surveys, exam results, images of distinctive facial features, and even partial body parts. So we recommend taking a conservative view when considering whether or not you're actually handling personal information. So does the Privacy Act apply to you? essentially the Privacy Act applies to public and private sector New Zealand businesses and organisations, as well as New Zealand residents. The Act will also catch overseas agencies to the extent they are carrying on business in New Zealand. So it has a broad extraterritorial effect. So what's new? What's come through this reform in 2020? And I'll take you through, during the course of this presentation, some of the key features of their reform. One we'll be talking about shortly is the introduction of a mandatory privacy breach notification regime. The new acts also introduce stronger protection relating to transfers of personal information to foreign entities, clarified certain matters regarding individual access rights, and has also increased the powers of the Privacy Commissioner. So the Commissioner can now issue compliance notices, which will enable or require businesses to do or to stop doing something. And the Commissioner also now has increased investigatory powers. New criminal charges have also been introduced. So why should you care about privacy? Perhaps that's an important question to ask. And I know a number of people consider the question in context of potentially low financial penalties under this legislation. Privacy is certainly front of mind for consumers these days. The reputational impact of mismanaging customer data can be huge, resulting in potential lost revenue and customer churn. In addition to potential breach of fair trading legislation and employment laws, obviously it comes with potential financial penalties under the Act, but individuals also have the ability to bring complaints to the Privacy Commissioner, which may be subsequently escalated through to the Human Rights Review Tribunal, where damages can be awarded up to $350,000. So there's certainly no good reason to be ignoring these obligations. So the first feature of the new legislation that a lot of people are focusing on is the introduction of this mandatory privacy breach notification regime. Essentially, what this means is if your business has been subject to or incurred a privacy breach, which is notifiable, that is a privacy breach where you have a reason to believe has caused serious harm to an individual or individuals, or may do so, then you are required to notify that breach to the Privacy Commissioner and potentially also the affected individuals. So what is a privacy breach then? Firstly, that occurs in respect of information or personal information, I should say, that is held by your business. And a breach will occur in respect of that information if it has been accessed on an unauthorized basis, accidentally lost, disclosed, or potentially destroyed, but it also may catch where an action has occurred that's restricted persons from being able to access that information. Only certain privacy breaches are notifiable. And as I've said, those are those breaches which are likely to cause serious harm to affected individuals. So there's an analysis to be done once you become aware of a privacy breach as to whether or not you consider that that breach has met the relevant threshold. While serious harm is not expressly defined in the Act, there are certain figures that should be considered in that analysis. Firstly, what actions have been taken in respect of the breach, whether the personal information in question is sensitive, i.e. is it financial or health data, or potentially identity details that could be used for fraudulent purposes. Also, whether the nature of the harm that's likely to result is likely to be emotional, reputational, financial, or may result in other loss of benefits. So helpfully, the Privacy Commissioner has introduced a tool available online at the Privacy Commissioner's website called Notify Us. And this enables businesses who consider that they've been subject to a notifiable privacy breach to test that, to go through an analysis to consider, in light of the nature of the breach, has that occurred? If you consider there to have been a notifiable privacy breach, then your obligation to notify the Commissioner is as soon as practicable. And it has been said to be within 72 hours, although that's not prescribed in the legislation. You must also notify individuals affected unless it's impracticable or unable to identify all those affected individuals, in which case public notice must be given as an alternate. There are also reasons why you might not look to notify the affected individuals. And those include factors such as where individuals affected may be under the age of 17 and notice may be against their best interests. Interestingly, a year on after the introduction of this regime, there has been a significant increase in notification to the Privacy Commissioner's Office. Over 4 times more breaches now being notified. Interestingly, a third of those breaches notified have met the threshold for serious harm. So we are seeing some over-reporting, at least initially. However, that is to be expected and indeed encouraged by the Commissioner. Interestingly, about a third of those breaches that reach the relevant threshold of serious, 36% of them were deemed so because of the involvement of emotional harm. And the majority of breaches were caused as a result of human error being the primary cause. The next point that the new legislation introduced was clarifying and strengthening the restrictions and controls around disclosing personal information outside New Zealand. Essentially, the default rule is that personal information may only be disclosed to foreign entities in certain prescribed circumstances. So what are these? These are essentially either where the individual concerned has authorized the disclosure after being told that the disclosure to the foreign recipient may not be protected in a way that's comparable to the safeguards provided under the Privacy Act, or where the individual or business that's disclosing the information overseas considers that the recipient is subject to comparable safeguards to those provided under the Act. There's 2 ways of ensuring that those safeguards are maintained. One is if you consider the laws in that particular jurisdiction to be comparable to the New Zealand privacy laws, or primarily and most commonly at this point, and what we would suggest is best practice, is where there's a contract or agreement in place between the discloser and the foreign entity recipient that allows you to get comfort that those safeguards are in place, or that foreign entity recipient is subject to protections or obligations comparable to those under New Zealand privacy laws. Helpfully, the Privacy Commissioner has prepared a set of model contract clauses. And these are a practical way for businesses looking to comply to adopt those contractual safeguards and make it clear and get comfort that that recipient organization is able to use and process that personal information in a manner that's consistent with our New Zealand privacy laws. One helpful point to note is that it's not considered a disclosure under the New Zealand Privacy Act if you are sending information to a cloud provider or an agent to store or process that information on your behalf, provided that agent is not using that information for their own purposes, then you are still considered as being primarily responsible for that information, and you're not considered under the Act to be disclosing the information to those agents. And therefore, the additional disclosure requirements do not apply. One additional feature of the Privacy Act, which is worth noting for business owners, is individual rights of access and correction of their personal information. So under the Privacy Act, individuals can come to businesses, organizations they consider to hold personal information about them and ask for a copy of that information, and if applicable, for correction of that information. It's worth noting that the request doesn't have to say, this is a request under the Privacy Act. It doesn't need to be explicit or use any particular language. It's simply a request for information, and businesses and organizations have obligations to assist with such requests. So you can't put your head in the sand and say, oh, that's not a Privacy Act request. I'll do a bit of back and forth before I need to respond in accordance with the Privacy Act regime. You have a proactive duty to help that requester get access to their information and facilitate that request. So if you receive a request, there are a few options. You can transfer the request to another business if you consider that third-party entity is best placed to manage the request. You must do so within 10 working days. Alternatively, you have 20 working days to respond to the request. And that is a limit. It's not encouraged to wait till the end of the 20 days before responding. You should be responding as soon as practical. Any response needs to say yes or no, we hold the personal information you've requested. And if yes, are you granting the access request? And if no, why not? What are the grounds for refusal? Interestingly and helpfully for businesses, you can charge for responding to access requests. There is a bit more of a control around whether a public sector entity can. Public sector entities needing to have been authorized by the commissioner before imposing any charge. However, for private sector businesses, you can impose a reasonable charge if that's reflective of the time and resources that were required to gather the relevant information. There are certain grounds which you can rely on to withhold information in certain circumstances, including a number of protective grounds. For example, if disclosure is likely to threaten the life or health or safety of any individual, or for security reasons. For example, if the disclosure is likely to prejudice the security of New Zealand or any international relations, or if the disclosure is likely to disclose a trade secret or unreasonably prejudice your commercial position. Other important grounds for withholding include where the disclosure will essentially involve the unwarranted disclosure of another person's information or breach legal professional privilege. There is also the ability to withhold information where the request is considered to be vexatious or frivolous or otherwise trivial. However, we encourage you to tread cautiously here. There is a high bar before you can be seen to be relying on this ground of withholding, simply because an individual is frustrating and coming to you with a number of requests doesn't mean that request in itself is frivolous. Each request needs to be considered in its particular context. So, how do you get prepared? How do you make sure your business is privacy compliant and up to speed with the new provisions in the Privacy Act 2020? There are a number of steps. We recommend in the first instance, a sensible thing to do is undertake a privacy audit. Essentially, this is data mapping, understanding what data or what personal information is collected by your business. Where is that information stored? How is it shared or otherwise processed? Undertaking this exercise allows you to understand the full life cycle of how your business holds and manages personal information and protects that information. Once you have done this, this is the first step to understanding where everything is sitting and getting your ducks in a row. Secondly, governance and internal training is vital. It's important that your senior members of your team prioritize privacy as an important factor for your business. As we mentioned earlier, this is becoming front of mind for most individuals and consumers. A business that's not managing their data appropriately or is considered to be flippant regarding their information practices will not be looked on favorably. And the issue needs to be escalated and prioritized at the more senior levels of management. Internal training, regular training for your staff is also vital. As you've heard, the majority of notifiable privacy breach incidents are attributed to human error. And so in order to manage that, regular check-ins with your staff to understand their responsibilities and how to manage incidents are also important. In terms of document review, we recommend that you revisit your supplier contracts. It's important that those you're contracting with can enable you to comply with your obligations under the Privacy Act. So are those suppliers essentially facilitating your ability to manage access requests or comply with your data breach notification obligations? If an issue arose at the supplier's end and that supplier is your agent, you're primarily responsible for that data. Is your contract allowing you to get that supplier's assistance in the manner you need it to? In terms of privacy statements and internal privacy policies, we also recommend you look and review those to consider whether they're up to speed. Privacy statements are the best way of ensuring you're satisfying your disclosure obligations under the Privacy Act. So when you're collecting personal information, you're encouraged or required to tell people certain things at the time of collection or as soon as possible afterwards. Privacy statements, online web statements are the easiest way of doing this. And you need to make sure those statements are clear and fulfill the role required under the Privacy Act. In terms of other policies, we also encourage you to set up a privacy breach response plan, essentially setting out how you would manage a breach incident when it does occur, what teams would be involved, what individuals, how would that be escalated. This just enables you to be prepared and respond quickly as and when needed. Also consider your protection of your data from a security perspective. What systems and measures do you have in place to actually protect that data? And insurance, finally, last but not least, how is your insurance going to respond in the event of a breach? So I'll leave it there, and unless there are any other questions, feel free to ask away.
Actually, I have one now. How do you deal with broad requests? For example, tell me everything you know about me, and that would relate to someone seeking their own private information from you.
Thanks, Michelle. So in terms of broad requests, I understand these can be slightly frustrating for many business owners, particularly where the individual is known to the business and has proven difficult in the past. The first thing to note is your primary obligation is to facilitate that request. And in order to get the best outcome for the requester, we'd recommend engaging directly to try and scope and understand the nature of the request, its subject matter, and see if there is any particular reason for the request so that it can be appropriately narrowed. Another way of controlling broad requests that seem to have no material justification is through charges. If you're in the private sector, naturally, there will be time and cost involved in collating the relevant materials to respond to such broad requests. And by informing the relevant individual that there is the ability for you to ask for a reasonable charge in connection with collection of that information, that may help whittle out some of the previous more trivial requests or time wasters. But it's important to note that your primary obligation is to facilitate that request in the first instance and work together with the requester to make sure you can streamline it.
Thanks, Megan. And another question here is about international privacy laws and whether there's anything additional that businesses need to consider when they do deal with other countries' privacy laws, such as the GDPR in Europe.
Absolutely. And this is the nature of the world we're living in, where things are now in the privacy space getting slightly more complicated for business owners. So where businesses are targeting consumers and based in other jurisdictions, so perhaps through direct marketing to other jurisdictions or selling through online retail to particular jurisdictions, specifically in the EU, then businesses need to be aware that other overseas privacy laws may apply to your business, irrespective of whether or not you actually have a business office in that particular jurisdiction. So New Zealand privacy laws, whilst being given the tick of approval as adequate under through the GDPR, we are a little bit more relaxed than GDPR requirements. And so there are additional requirements under a number of international privacy laws that may trigger if your business is selling or marketing to overseas individuals. So it's important as part of that data mapping exercise we talked about to potentially identify early what individuals' information are you collecting and from what jurisdictions, so you can seek local advice on those particular privacy laws in those jurisdictions early.
Thanks, Megan. And for businesses, the requirement to have a privacy officer, does that apply to any size business?
So yes, every agency that's subject to the Privacy Act is required to appoint a privacy officer. It's important to note that that officer does not necessarily have to be any particular person. The aim of the privacy officer is essentially to have somebody to funnel through privacy requests and manage those requests, and also be the front person to engage with the commissioner in respect of any matters that may require escalation, and generally just make sure that the business is prioritizing privacy internally. So whilst it may seem an onerous obligation for some smaller businesses with a small number of employees, it's important to note that you can also outsource that role as required, and you can also appoint, there's no reason why you can't appoint a senior manager out of those employees to fulfill that role.
Thanks, Megan. That's really helpful. If anyone does have any further questions, we will cover them off at the end. So I'm just going to hand over to Josh now to look at changes to the Fair Trading Act and unfair contract terms and unconscionable conduct regime.